My name is Massimo Lando. I am Assistant Professor of International Law at the School of Law of City University of Hong Kong, and also one of the editors of CIL Dialogues. CIL Dialogues is the blog of the Center for International Law of the National University of Singapore, and I would like, on behalf of CIL Dialogues, to extend my warm welcome to everyone that has tuned in for the session today. Now, CIL Dialogues is a blog, as I said, of the Center for International Law at NUS, which first of all wishes to retain a generalist perspective in promoting scholarship on international law, and second, which also takes stock of the fact that it is based in an institution which is not based in Europe or North America and wishes to promote a regionalist approach, amongst other things, to international law. Now, today's conversation, the topic of today's conversation is the flurry of interventions in the case currently pending under the Genocide Convention between Ukraine and Russia at the International Court of Justice. The conversation stems from a blog post that was written by three of the persons that are in conversation with me today. A blog post with a catchy title, "We read 22 intervention declarations, so you do not have to." And here in conversation with me are the three authors, Juliette McIntyre, Ori Pomson, and Kyra Wigard. Joining us today is also, as our distinguished discussant, Professor Attila Tanzi. By way of background, the case between Ukraine and Russia under the Genocide Convention began in February 2022 in the context of Russia's unlawful aggression of Ukraine just earlier during the current year. In the last few months, we have witnessed a number of states intervening pursuant to Article 63 of the Statute of the International Court of Justice in the case in question. And of course, the number of interventions is unprecedented and has generated a number of, a degree of interest in the scholarship and beyond as well. And of course, the three persons here today are amongst the ones that have taken the keenest interest, I would say, in the developments that have been taking place in the last few months. So I would like to kick off the conversation, of course, but remind everyone that I would like to have about 15 minutes at the end of this conversation for Q&A. So if anyone has any questions during the discussion, please feel free to put them in the chat. I will be collecting some of them, all of them if possible, and of course direct them at the speakers as appropriate. So to begin, I would like to kick off the conversation asking, first of all, can the court declare the absence of genocide, and why is that relevant in the question, the case before us? Please.
I'll start. So hello, everyone, and thank you very much for hosting this CIL Dialogues and Massimo for organising. I'd just like to acknowledge that I'm coming to you from the lands of the Ghana people and pay my respects to their elders, past and present, before I continue. So, yeah, can the court declare the absence of genocide? I mean, you've really sort of gone to the heart of one of the major issues in these interventions, because this really comes down to the question of, what is the scope of the court's jurisdiction? And it's interesting because the interveners are largely unanimous that what Article 9 of the Genocide Convention does is bestows on the court competence to adjudicate upon disputes that don't only concern the commission of acts of genocide, a traditional sort of, conception of a case of this nature, but also covers non-violation complaints, and in particular, the alleged fulfillment of the terms of the convention. I use scare quotes because that is, it's in Article 9, the fulfillment, and it's an unusual term to have in this kind of compromissory clause. And a number of states in the intervening, or a number of the intervening states also make the point that the term dispute in the court's jurisprudence is wide enough to encompass a disagreement over the lawfulness of the conduct of an applicant state. So this is really a question of whether the court can issue a negative declaration, and a number of states are using that terminology. It's really a declaration of compliance with the convention rather than a declaration of an absence of compliance or a breach. And look, in my view, I think that the court can. A declaratory judgment is just a statement regarding a legal relationship. It doesn't have to contain any kind of order that is enforceable, and it can be a declaration regarding the absence of a legal justification. So that's my view on that one anyway.
If you don't mind, a follow-up question on that, Juliette. Has it ever happened before that the ICJ has either given such a negative declaration or has been requested to give any such a negative declaration?
Yes, so Ori or Kyra might jump in with additional information here, but the Lockerbie case involved this kind of negative declaration where there was an application essentially to say, look, we didn't do anything wrong here, we didn't breach the convention. So it has happened once before. It is slightly unusual, but I mean, declaratory judgments can be about anything, really. They cover a huge swathe of different types of orders that the court will often make. So really, I don't think there's any particular limitation on the court's capacity or function here which prevents them from doing this.
If I may chip in, Massimo, just
please, Attila.
I fully subscribe to the approach followed by Juliette in very general terms, and in this particular case, I mean, we have a compromissory clause which refers to dispute, and dispute is to be understood, interpreted, and applied by the court in its traditional and traditionally wide terms as they have been defined by the parties here, the application. So if there is jurisdiction which may come down to a declaratory judgment, as appropriately emphasized by Juliette, why should the declaratory judgment bear on the conduct, on the compliance or non-compliance with the applicable law only by the defendant? So if it is appropriate for the court to hand down a declaratory judgment on the defendant, it can just as well do so with regard to conduct by the applicant. And looking for other precedents next to the one mentioned by Juliette, and with specific regard to genocide, I would like to recall Croatia-Serbia of 2015, where the court came down very explicitly declaring that Serbia did not commit nor conspire to commit an act of genocide. So I think that stands as an interesting and useful precedent. Thank you.
Thank you, Attila. Juliette has called out on Ori and Kyra to say anything about the existence of previous declaratory judgments or negative declaratory judgments. Would you like to add anything to what has been said so far?
I would just add, well, firstly, thank you very much for hosting us, and it's a really great honor and privilege to be here. I would just add that if we go quite far back to 1952, where the court decided the US nationals in Morocco case, and in that case, France instituted proceedings against the United States based on the optional clause declarations and existing optional clause declarations of the two states, and essentially requested from the court a negative declaration in the sense that it wasn't violating certain obligations towards the United States. The issue was somewhat touched upon by counsel for France in the oral proceedings, noting the peculiarity of the proceedings, but explaining that simply because the United States wasn't willing to take the case through a compromise to the court, and that's why it instituted proceedings. But the court didn't make much of a fuss about that, didn't even touch upon it, and even separate opinions. And I think it's for the reasons which Juliette rightfully highlighted, that there's no issue here, at least to the extent of the limitations of the judicial function or the jurisdiction of the court under the compromissory clause, to request from the court a declaratory judgment which puts an end to a dispute regarding the legal status of the parties' relations.
Well, that's very appropriate. In fact, a number of intervener in their declarations have mentioned that particular case, including Latvia and Italy as well. So that's very appropriate indeed. Thank you for that.
Yes, I must also say that I sort of forgot at the beginning to flag that Attila is actually acting as counsel for Italy in the intervention procedure. So, of course, there is a disclaimer to be made there that anything that he will say is said in a purely personal capacity during the conversation today. Now, I would like to shift for a second away from the idea of a negative declaratory judgment and instead focus for a moment on the definition of genocide. Now, of course, one of the big questions is what states have been saying in the intervention declarations concerning what genocide amounts to in international law and how they have been adding to the ICJ's jurisprudence. So I wonder whether anyone on any of the three authors would like to take up this particular aspect of the issue.
Perhaps I can start with that part, because indeed it's quite interesting to see that not all interventions, in fact, go into a discussion of more substantive issues. And it was quite interesting to see that a number of states, and the ones that come to my mind now are Sweden, Spain, those declarations are also quite similar. They actually say that there is a need to establish sort of prima facie whether allegations of genocide are there, is necessary for the court to decide already now at this stage on jurisdiction. And I think I'll let the others also chime in there, but it would mean that if the court is not satisfied by the arguments made now by Ukraine and or Russia, the court could actually decline jurisdiction in this case, which is a very interesting argument to be made by some of these states that I think all of us are quite curious how the court is going to deal with even acknowledging and discussing that observation.
Any other remarks on this from the other two authors by any chance? Again, called on by Kyra.
I wholeheartedly agree with Kyra on this point, and I would add that there seems to be a conflation going on here between, at least in some of the declarations of intervention, between the ICJ's jurisprudence regarding provisional measures and the ICJ's jurisprudence on issues relating to the merits. As Massimo probably knows much better than all of us, as he's written a whole piece about this. In provisional measures, you do need to prove prima facie jurisdiction in order to get provisional measures. And what these states have been doing is they've been drawing upon the court's order in one of the court's orders in the legality of use of force case, which concerned the Genocide Convention, but in a completely different context, where Serbia, or then Yugoslavia, was arguing that NATO states were committing genocide by intervening regarding Kosovo, militarily intervening regarding Kosovo. And the court declined to render provisional measures because Serbia or Yugoslavia hadn't proved at a prima facie level that there was in fact jurisdiction. But this is entirely different from the circumstances which relate to the issues of jurisdiction relating to the merits as to whether or not Ukraine has or has not committed genocide or not. So I think there's a bit of conflation going on.
I suppose that the question that, of course, comes to my mind as someone that has been studying provisional measures somewhat in the last few years is the degree to which, for example, the whole plausibility jurisprudence might come into play and affect what is happening at the moment at the preliminary objections in the Ukraine-Russia case. And the reason why I'm asking this is because in another case involving Russia, the one, well, also Russia and Ukraine, actually, the other case under the Terrorism Financing Convention and the Elimination Convention, there was a whole argument being made by counsel for Russia in the oral proceedings that the court, in order to determine if it has jurisdiction, it must be satisfied that the claims of an applicant state are actually plausible. They satisfy some sort of prima facie review of the merits, so to speak. So I was wondering whether you think that this might actually be another one of those aspects that can come into play in future preliminary objections judgment in the second Ukraine-Russia case, so to speak.
That's for you, Ori.
If that's the case, if I'm not mistaken, ultimately the court didn't really accept that argument in that case. It wouldn't be surprising, I guess, if Russia tries to raise it again, tries to frame it otherwise. We see that happening quite often. So United States on a number of occasions has tried to raise real issue objections to claims brought against it, and each time has tried to frame it in a different way. So I don't think it would be surprising, but I think ultimately at the end of the day, all Ukraine really needs to do in this regard is kind of bring it back to the essence, and that is whether or not the court has jurisdiction. This was something which was laid down by the court in the 1996 oil platforms preliminary objections. It's whether the facts, as proved correct by one of the parties, assumed to be correct would amount to a violation of the provisions. Ultimately, here it's a bit of a different issue because the question is less whether or not the acts amount to a violation as to whether or not the acts don't amount to a violation or come within the treaty. But I think ultimately that is an issue for the merits, as long as jurisdiction is as long as the court finds that it has jurisdiction to address negative declarations.
So overall, do you think that the flurry of interventions that we have seen so far is going to be helpful to Ukraine, for example, in establishing the court's jurisdiction? Is it going to be neutral? Can it be detrimental? What is the feeling in the room?
Well, I think this whole discussion on jurisdiction and the fact that Russia has taken a stand informally initially, and now is anticipated is going to take formally a stand, points in the direction of a jurisdiction issue being key. And I think that the big question whether under Article 63 you can intervene for the purposes of construing non-substantive provisions as well, whether this is too long a short. I think that the key discussion for the purpose of the exercise of its judicial function for the court, the interpretation of the compromissory clause in 9 becomes key. And of course, you apply a compromissory clause as much as you apply and interpret any substantive provisions which bears on the merits against the backgrounds of any disputed facts. Obviously, the intervener are confined to keep within the construction in as much general terms as possible, and they can assist the court. So I think that there is not only a literal interpretation of Article 63 to the effect that there is no exception whereby you can intervene to construe a provision which is instrumental in the merits of the case. And if I can link up to the this question to the follow-up question that you're putting, Massimo, whether there's going to be the benefit of the applicant or not, and whether this massive wave of interventions is sort of altering the equality of the arms. I think that we should not forget the very simple fact that any state party could intervene. Whether this would eventually turn out an interpretation submitted by a party would be to the benefit of the applicant or the respondent, that's absolutely immaterial as I see it with respect to the admissibility of the intervention, which, by the way, is a right under 63 and not as it would be under 62, where you have to prove material interest of some kind, or certainly strong legal interest. So there would be nothing preventing a state party to make an intervention, to declare its intervention, which would eventually benefit the defendant. It hasn't happened so far, but for the purposes of the application of exercise of the judicial function by the court, on the face of it, I think that that does not matter whether an intervention benefits the applicant or the defendant, so far as an intervention could be made purporting to present and assist the court with whatever interpretation it is. I think it is absolutely legally neutral. The important constraint, and I'll close my remarks with that, is certainly that no intervener should get into the facts whatsoever in terms of providing any evidence on the disputed facts. That is certainly an important constraint. Thank you.
I suppose that the question that arises to my mind is, well, all these interventions, which by the way now are 26, not 22 anymore, as the title to the blog post a few weeks ago said, is whether these interventions are actually going to be helpful to the court, in the sense that, of course, they add a certain volume to the pleadings that already are expected in The Hague. And of course, I imagine that a question is, well, how much weight will the court give to these interventions, provided that they're actually accepted and declared admissible? Yeah, so that would be my follow-up question, basically.
I'll interject because Professor Tanzi's raised some really interesting points. How helpful is this volume of material to the court? Well, from a practical point of view, I mean, obviously it's going to create a lot more work for the court, having to sift through all of these arguments, which, while largely identical, are not absolutely identical. There's a lot of similarity and overlap, but they're not precisely the same. But what's interesting is if you look back to the history of when Article 63 was drafted, what you can see is that the intention behind Article 63 was this harmonious interpretation, if you will, of a treaty. The idea was that you would get the states parties, who are the authors and the owners of the treaty, if you will, to come together and actually say, oh yes, when we drafted this, we meant X. So in a way, if the court takes that view, that sort of historic view that this is the purpose of Article 63, then in a way the interventions can be quite useful, because they can look at this large volume of agreement between states parties and say, okay, well, clearly this is what you all meant, you know, in terms of what your intentions behind the interpretation of Article 9 were. So so it kind of cuts both ways. It's practically sort of challenging, but also you know, it could be beneficial.
Now, I have to say, having had the pleasure and privilege, if you want, of working at the court for a few years, I imagine that everyone in the halls of the ICJ right now is in deep despair, because they know that we'll have exactly to go through with a tooth-fine comb, basically, all these different arguments and what the nuances mean and so on. Of course, if I know anything about the court, they will take the nuances into account and they will make something out of it. I guess that we can only know once the judgments, for example, or any other decision anyway, gets handed down that takes into account what is being said in these intervention declarations. Yes, so one question that arises, of course, is also what the implication of the mass character of this intervention is or could be for the proceedings, of course. One question that I have to say we were thinking of approaching during the conversation today, but that I also just got in the chat from one of our listeners, is whether there is any possibility of grouping these interventions together. And I was wondering if anyone would be able to speak to that for a little while.
Oh, I'm happy to take that, but again, you're probably sick of hearing my voice. So Kyra and Ori, please do jump in. What I will say is that there's no precedent for grouping interventions. There was one case, the request for an examination case involving New Zealand, where you know, the sort of infamous nuclear tests cases where France never showed up, and then there was a judgment rendered, and there was a weird paragraph in that judgment that said, oh, look, if anything changes, you can come back to the court. And New Zealand said, oh, actually, yeah, we'd like to come back to the court. As part of that, four, I think, maybe 5 states from the Pacific applied to intervene. So Micronesia, Samoa, a couple of others, forgive me for not remembering them all off the top of my head. But what was interesting there was that they submitted literally identical declarations, word for word. I went through them all, you know, except for the name of the state and the, you know, date of accession to the treaty. So that was the first part. And then the second part was that they all appointed the same agent. A Samoan diplomat was their agent for all of the parties. So we can assume that in that circumstance, they would have all come together and said, yep, this is our one set of, you know, submissions, as it were, in respect of our intervention. Here, of course, it's really different. We've got a number of states who have said explicitly they're happy to work as a group. We've got other states that haven't said that. It certainly seems like it's a trend that once a couple of states said that, now all of the recent ones have been saying that as well. I think it's getting to the point where it's obvious that the large numbers are going to pose some practical problems. And so a lot of states are willing to group their submissions together. But what exactly that looks like isn't clear. you know, what does it mean to group your submissions with someone else? Does it mean that you write a new declaration? Do you, you know, do you kind of just say, okay, these are the key points and the things we all want to say, but also you need to read our separate written declarations because we have slight subtlety, you know, subtle differences. It's certainly very challenging from that point of view. I'm sure Ori and Kyra have something to say about this as well.
Do you?
Well, I would add to that perhaps that indeed it was quite interesting to see also which states so far have been indeed indicating very explicitly that they would be willing to cooperate with other states, and I think often it was called like-minded states even, to sort of assist the court also in its administration. And I think this will be one of the areas, given that we see such an unprecedented number, where there's also real, I would say on the one hand, it's a real opportunity to sort of see what happens if then some of these states start working together and indeed expressing how they interpret certain elements. On the other hand, by then creating perhaps a sort of group within the group of all the intervention declarations, I also do wonder what that would do to the interpretation in general, and also how the court is then going to deal with that. Just because an X number of states is like-minded or is willing to cooperate on some of these things, what does that mean, or does it mean anything at all? So I think on the one hand, that's another real opportunity that we can see from this entire development. On the other hand, I do also really wonder what it would entail on a more substantive level for the court.
So I suppose that there are two follow-up questions that come to mind listening to Juliette and Kyra's remarks. First of all is, what kind of problems could be created by the sheer mass of these interventions? And the second one, actually, following up on the point about interpretation. Now, because we all love some formalism, do you think there's any chance that for example, the agreement of particular states over a number of states concerning how to interpret certain parts of the Genocide Convention would fit within any of the recognized means of interpretation under Article 31 of the BCLT, or do you think that this is something that we have never seen before and something that instead has to be taken from a different perspective altogether?
So I'll have a go at the bat. I think one of the main problems, I think actually from a more legal perspective, and here I'll probably take a bit more nuanced approach on this, relates to the issue of the equality of the parties. A lot of the interveners have cited the court's order in 2013 in the Whaling case, where New Zealand was effectively intervening in support of Australia. The two states made no secret about it. They issued a joint press release explaining how they were collaborating. And the court said that the intervention, in one sentence, that the intervention does not affect the equality of the parties. I think that, firstly, there are some more, I guess, doctrinal issues with that. I think those are echoed in Judge Owada's declaration appended to the order. But I think it's a bit disingenuous to draw from the court statement in that case, where essentially one state was intervening in support of the applicant state, where here we have 26 and counting states intervening in support of Russia. Of course, third states, perhaps our North Korea, Syria, Iran, can come out in support of Russia, but at least at the moment does not seem very likely in occurring. Regarding the second question, I think we need to be a bit more cautious if we can say that these interventions can really formally have something to say through the Vienna Convention rules on treaty interpretation. Ultimately, state practice subsequent to the conclusion of a treaty can be a form of interpretation, though as the ILC recently emphasized in its draft conclusions, it needs to be state practice which is participated in or at least agreed to by all the parties to the treaty. And in this regard, it's important to note, firstly, that not all the interveners have addressed all the various issues, and particularly probably on the more difficult issues for Ukraine, the issues relating to whether Russia's abuse of the convention amounts to a violation of the convention. But I think also we need to keep into account that it's primarily, if in fact solely Western states, or to be more precise, Western Europe and other states and Eastern European group states. We haven't seen any states from beyond these groups intervening in the proceedings. So at least to analogize with the rules for developing customary international law in this respect, where we usually demand representativeness and a representative of geographical regions and interests. In this regard, we don't see that happening. I'm sure this is something which might be concerning to those involved in supporting Ukraine's case. I don't think it necessarily undercuts Ukraine's argument, but I think it certainly poses an obstacle when it comes to issues of treaty interpretation and trying to formalize the interventions as means of interpretation.
Following on from the remark concerning Attila, sorry.
Unless Kyra has a comment on this particular, I would like to comment on what has been said by Juliette and Ori. I mean, as far as to the Ori's answer to your follow-up question, I fully subscribe to his reply, and the story in principle is not over yet. New interpretation, declaration of intervention could come in still, and we don't know what the substance of these interpretations and to the benefit of whom they could result. And so not to be old-fashioned formalistic, but I think I wouldn't put even the soundest of a declaration of intervention and the best of interpretations to be any more persuasive than the statement of fact that they simply reflect the view on the specific circumstance of any given case, even though interpretation may be in the abstract, but that is only in principle. As we said, interpretation and application are only to a very little extent two different kettle of fish, as I personally see it. It's very difficult to interpret if you don't have a kind of an application in mind, and you can't apply a piece of law in the abstract without interpreting it in the light against the background of given facts. So that being said, that was my comment to the answer by Ori to the follow-up question. As to Juliette's remarks, and I think also Kyra's, I mean, we are thinking in terms of grouping or not grouping based on the attitude of the interveners. But what, and the willingness or non-willingness, I think there was a fair amount of openness and goodwill on the part of a number of interveners in principle in favor of grouping, and then individual sovereign state clung to their own individual, say, legal, political prerogative to make their own statement. But what about the reaction by the court? There is the big question mark again on the face of the fact that from the procedural standpoint, inevitably, this is not going to render proceedings any smoother. But I think that even though, as Juliette rightly pointed out, there is no significant or any real precedent from the procedural standpoint here to come to the rescue, I think that perhaps some kind of procedural analogy can be drawn from what happens when you have advisory opinion proceedings. There you have many states expressing their views, which are often very close one to the other, and they are being handled procedurally pretty fast and without too much of an inconvenience to the timetable of the court. That's the way I see it.
Thank you. Actually, that sort of preempted the question that I was going to ask, abusing my chair's prerogative. You know, what is the degree to which the proceedings in front of the court in the Ukraine-Russia case are morphing into what essentially is some sort of an advisory proceeding, but not really, because of course we don't have the General Assembly acting as a gatekeeper in this particular case. States simply can file their intervention declarations, and that's pretty much it. Now, one question that I just received in the chat, actually, and that follows on from what was being said about the majority or all of the interveners coming from particular parts of the globe, is, well, first of all, why, or can we speculate as to why the majority of interveners comes from the Western European and other group states? And what is the significance in all of this also of the intervention, or anyway the information provided by the European Union, of course? Would anyone like to take this one?
Well, I'll just comment briefly on the significance point, which is largely that there's a perception of imbalance, I think, if we compare the situation in Ukraine to the other genocide case that's currently on foot, which is the Gambia-Myanmar case. And there were a few states, Canada, the Netherlands, a couple of others, who, the UK as well, who has intervened in the Ukraine case, who have said that, oh, yeah, we're going to intervene in that case. Yeah, we're concerned with the commission of, you know, horrific acts of genocide against the Rohingya people. This is a more traditional case involving, you know, claims of the commission of acts of genocide. We're going to get involved, but no one has. And so there is a question, I think, in the back of some people's minds as to whether this case is considered to be well, you know, a kind of instance of Western bias, if you will. You know, that's been a comment that's been made about the attention given to the Ukraine war in general. I don't think it's necessarily fair or made out, but it's a comment that's been made. But we don't know what the reasons are behind the scenes, you know, as to why there haven't been interventions in the Gambia-Myanmar case. We don't know if the Gambia is going around saying, no, stay out of it. We don't want this mess that's happening in the Ukraine case. Go away. You know, so there could be, you know, justifiable reasons for this that don't come down to questions of bias. But, you know, it certainly looks, yeah, a bit one-sided, if you will.
Juliette, if you don't mind a follow-up on that one, do you think there's any chance that the Gambia-Myanmar case might actually benefit, quote unquote, indirectly, even without interventions happening in that case? Might they benefit from what is happening in the Ukraine-Russia case at the moment?
Yeah, I think not, because that case has already overcome the most significant hurdle, which is the jurisdictional question. So if anything, it's the reverse, this idea that, you know, the Genocide Convention is erga omnes, or erga omnes partes, and, you know, any state can bring an action, and, you know, it's there for everyone to get involved in. Everyone should be making sure that it's upheld and not abused. That was found in the Gambia case, because of course that's how the Gambia got standing. So if anything, it's that case which is going to aid here in the approaches that are being taken to the interpretation of the convention, rather than the opposite. The Gambia case is now moving on to the merits question, and so there's really not a lot for interveners to say anymore in that case. You know, this idea of interpretation. I mean, possibly, you know, questions of interpretation of Article 3, maybe, but really it's coming down to a question now, if we know what genocide is, has it occurred in Myanmar? So there really might not be much to be said. So it is, the one weird anomaly I will point out is that the UK said it was going to intervene in that case after the preliminary objections decision. So all this rationale I'm giving explains most of it, but not all of it. So it'll be interesting to see what the UK does there, whether they've got something to say on the merits or not.
Thank you. Shortly, Massimo, on this. I fully agree with Juliette on everything she said. To some extent, the case has lost a little bit of momentum, and it has been hit hard by COVID. I think had it not been for COVID, there might have been interventions. The interesting thing that from a scholarly standpoint, which could have an impact on the actual case, is that the difference that I see between this case and Myanmar for the purpose of intervention is that there would be room for Article 62 interventions, precisely based on the erga omnes nature of the obligations infringed. And you may say, yes, but we are talking about the same convention and the same kind of obligations, except that here we are in the presence of a non-violation claim, whereas in Myanmar, in the Myanmar case, we are in absolutely traditional dispute where intervening states could put on the hat of a party, so to say, insofar as they don't have to prove any more legal interest than Gambia did. And there, the situation will be completely different from the one we are talking about today, where intervention is just there very purely for the purposes of interpretation of the convention. That would be the legal interest, having the integrity of the multilateral treaty interpreted appropriately, whereas in the other situation, you could have states going as far as to intervene under 62 and take a proper stand in the dispute as a party.
So there's a question in the chat concerning the next procedural steps in the case and whether there's any chance that the court might decide on its own jurisdiction before it touches on the admissibility of the declarations of intervention. So what do you think might happen in the future?
Kyra, are you trying to unmute? Okay. So what we do know, well, there are a couple of things we do know. Something which was revealed by some of the latest interveners is that the registrar did send out a letter requesting, we don't know how much this is a please, pretty please request, or whether it was like, or else, that the interveners, the states planning on intervening submit their interventions, declarations of interventions by the 15th of December. So it would, at least for me reading into this, it does seem that the court does want to kind of centralize this process and address these interventions in a centralized manner, and probably sooner rather than later. Ultimately, we also do know that Russia submitted preliminary objections. So, and Ukraine, I think, probably has a couple more months to submit its observations on the preliminary objections as well. But considering that the court is requesting parties to submit their declarations and interventions, and by the 15th, it seems that the court will seek to address these issues before the proceedings, or at least the oral proceedings on the preliminary objections. But again, we don't know so much other than speculating based on what these intervening parties have provided.
Yes, I mean, I guess that I was very surprised personally when I read of the registrar sending out a pretty please note or an or else note to states saying, please give us all the interventions by the 15th of December. I was actually quite surprised that instead there wasn't a formal order being made by the court or by its president to this effect. And I've been trying to think about why that was the case. I guess that perhaps if there was an actual order being made by the court itself or the president, some states might see it as curtailing the right to intervene under the statute. Instead, the registrar just acting behind the scenes might seem a softer way of limiting the number of interventions. I guess that come 15 December, everyone at the court will be just signing relief that all of this has finished, perhaps, I guess. So going back for a moment. Yes, please, Kyra, sorry.
To add to that, because this does mean that if you want, as a state, you can also still submit your declaration after 15 December. I mean, it's a request. The registrar, that's also how I see it, because it's not formalized in a way that one would expect. It is still very much possible that then, I don't know, in the new year, there will be an entire new wave, who knows, right? Also as things develop. And I thought actually that was one of the more interesting elements of why this approach was taken. And it's definitely leaving the door open for more, I would say.
So going back to the question that was raised by Attila earlier on about the morphing of this procedure into an advisory one. Now, as I was saying, the problem that I see anyway in that idea is that, of course, when you have advisory opinions being requested to the ICJ, there is a gatekeeper, and that is the General Assembly or the Security Council, usually the General Assembly, because there was only one advisory opinion from the Security Council, if I remember correctly, since 1945. Of course, in that situation, the timetable is very different, and it's organized in a different way at the court. And then, of course, also the advisory opinion technically has no binding character. And I say technically because we all know what happened in the recent Mauritius and Maldives case at ITLOS. So I was just wondering whether you think that in the context of the Ukraine-Russia case, what is happening right now could be replicated in the future, for example, when, say, an advisory opinion is not being passed in a General Assembly, whether there's any possibility that a state might actually start a case, treaty-based, of course, and that, in a way, being followed by a number of interventions to circumvent the inability of getting an advisory request through the General Assembly. Do you think there's any chance of that happening in the future?
That's a really interesting question. And I hadn't thought about it from that perspective before, because, of course, I was sort of coming at it from the other point of view, thinking about the Chagos advisory opinion, where, you know, you had what is basically a dispute that got in through the advisory opinion stream. And I mean, and in practical terms, I mean, it was interesting the way that they handled the oral proceedings there was that I believe that the UK and Mauritius had longer speaking time, I think, than the other states. Correct me if I'm wrong. So you could see something quite similar happening here. Basically, you run it as a standard party case, but for everyone else, it's basically like an advisory opinion. You get 15 minutes, you know, 20 minutes, get up, make your point, sit down again, and the court will just run through them. In terms of whether or not this could set a precedent, though, for states who can't get an advisory opinion to then try and get a binding, you know, party case that everyone will pile into, it's a really interesting idea. I mean, it depends, I guess, on whether you can find a compromissory clause that's sufficiently broad to jackknife your issue into. And it could well be that the interpretation offered here will set up the Genocide Convention for more types of claims of that nature. But yes, Ori, Kyra, have you got, as you can see from my rambling, I haven't thought this through. So have you got anything more intelligent to say?
I think it's somewhat unlikely that this would occur. At least in recent years, the advisory opinions which have been submitted on contentious issues have primarily been submitted in instances in which at least one or even both of the parties don't have any standing acceptance of the court's jurisdiction in order to bring the case. So in the Chagos Archipelago case, of course, there was an attempt by Mauritius previously to fit the dispute with the United Kingdom in Annex 7 arbitration under the United Nations Convention on the Law of the Sea. That didn't work. There was no other standing consent, so Mauritius essentially brought the advisory proceedings. In the Kosovo advisory proceedings, ultimately because Kosovo isn't at least then status as a state was very much disputed, so that again was a way to find a way around. Construction of the wall, very similar issue, and coming up likely or soon another advisory opinion regarding the Israeli-Palestinian conflict. And there are more and more examples of these as you go further back in history, all the way to the Southwest Africa and Namibia disputes to a certain extent. So I think it is somewhat unlikely that the intervention process will be seen as an alternative to the advisory proceedings, but I think it is perhaps more likely that the intervention process will be resorted to more often as a means of either expressing solidarity or supporting another state in proceedings. As was alluded to earlier, this isn't the first time in recent years where we're seeing this happening. Already before the war in Ukraine started, a few states had come forward, namely the Maldives, Canada, and the Netherlands, in support and expressing their intent to intervene in the Gambia case, and they still intend to intervene in that case. So I think this might be the beginning of a trend to express support in instances where you can get a contentious case.
So following on from what you're saying, Ori, so to the extent that these interventions are intended to signal solidarity for Ukraine's position in respect to Russia, do you think do you or any other person, of course, on the panel, do you think that the purpose of the Article 63 procedure was envisaged at any point to be the expression of solidarity? And do you think that can justify, in a way, a state's intervention?
Well, the first ever time intervention was used in the Wimbledon case, it was essentially an expression of solidarity, because you had a situation where, it was about allowing military transports through the Kiel Canal. France was the applicant state, but actually a number of other states submitted a joint application with France, but it only really concerned them in terms of whether they could get reparation or anything like that. So you had a joint application, and then Poland kind of jumped in and said, oh, I'd like to get involved as well. But again, they weren't actually doing much. They were just really expressing solidarity with the applicant states, saying, yes, no, Germany, naughty, very bad. We disagree with what you did. So there's not a lot of practice in respect of Article 63, but what practice there is, Wimbledon, whaling, often seem to have this kind of, we're coming in solidarity approach anyway. So, I mean, this is certainly the most explicit it's ever been. The statements coming out from foreign ministers have been, this is about standing up to Russia, and then someone's whispering in their ear, it's about interpretation. And they go, oh, yes, and it's also about treaty interpretation. So this could lead to an even more explicit use of Article 63 as cooperative condemnation, but I think that the trend has actually been there right from the get-go.
Very good. I sort of actually have always thought of the intervention in whaling, for example, as one of solidarity myself. Also considering that the two states, New Zealand and Australia, had already been together, had banded together in the southern bluefin tuna cases just a few years ago. A few years before the whaling case, which in a way could have foreshadowed what was going to happen in the whaling case. But that, of course, also was potentially a case about obligations of legal omnes, although the court didn't say anything about it in the judgment under the Whaling Convention, and potentially there could have been, I guess, some more interventions in that case as well. But probably there is an impact also of the political relevance of a particular case to a certain set of states, for want of a better way of saying it. So I see that we have 5 minutes left before the hour is up. And now I haven't seen any additional questions coming through in the chat, but I would like to ask whether there's anyone in the audience that would like to ask any questions before I abuse once again prerogative of the chair to ask even more questions. I see nothing coming through for the moment. So I guess that another question perhaps that I could ask concerns the degree to which, well, there have been some ideas being floated around that perhaps what states are doing actually in filing all these declarations of intervention is a lot of virtue signaling that actually is not going to be particularly useful in helping either party to the case, well, especially Ukraine in this case. Now, do you think that there can be any truth in that assessment, or do you think that this is just this is not correct, so to speak? This is not a fair assessment of the situation.
Well, perhaps I can start with that. I think that indeed, as also all of you have referred to, we also really have to see this in the sort of political reality that has been going on. And there have been even from Ukraine indications that they appreciate the support, so to speak. They appreciate these intervention declarations, that they're part of this. But then you see, as you're rightfully saying, Massimo, that some of the elements then that some states go into in their intervention declarations could in fact not be that helpful to Ukraine's case. Like, as I referred to before, in them requiring a sort of assessment of genocide already. And Juliette actually was on a panel not that long ago where she also interacted with some Ukrainian officials who also said, like, no, we don't necessarily plan to go this route. And then to see that in quite a number of state interventions that interveners have been going down that road, you can ask, I think, very validly the question, how helpful is this going to be in reality, as in the legal, the court reality that we have here, rather than the broader political reality that is going on?
Does anyone think we can say anything about how this flurry of interventions is being seen from the perspective of the defendant in these proceedings? You know, how do you think Russia is seeing what is happening?
Well, I have a controversial opinion on this, which is that they might actually quite be enjoying it. To the extent that Russia likes to position itself politically, and this war in particular, as being against the West, the fact that you've got all of these, you know, it's not about Ukraine, you know, it's actually, you know, it's Putin versus the West. And the fact that you've got all of these Western states intervening to kind of gang up and, you know, bully poor old Russia, could actually help their narrative, certainly, you know, in terms of a domestic audience back home. So there's that side to it. I mean, I don't have any, you know, lines into what they're thinking in the upper echelons of Russian legal circles, but you know, they could kind of use this as a narrative, and they could in fact, you know, jump on these ideas about party equality and the unfairness of the proceedings. It'll be interesting to see what they actually have to say about that.
I would just add to that I think it was a Security Council meeting which was organized when Albania had the presidency of the Security Council, on issues of accountability in international law, and among others invited the president of the ICJ, Judge Donoghue. And I think this was after the press release, the joint statement of the 42 states and the European Union expressing their intention to intervene. And Russia said in no uncertain words that these Western states are trying to pressure the court, coerce the court into supporting Ukraine. And so just to follow on from what Juliette said, I think this very much fits the Russian narrative in this regard. And probably this will be, at least in its rhetoric, one of the things it will be arguing.
Okay, so we've just hit the 6 p.m. mark, at least in Singapore and Hong Kong. So I would like to bring the discussion to a close and thank the speakers, of course, three of them, Juliette, Ori, and Kyra, and of course, Professor Tanzi as well, for joining us today. Thank you also very much to everyone that has joined from all corners of the world, and we hope to see you very soon again on yet another one of the CIL Dialogues conversations. Thank you very much.
Thank you.